Hello everyone. Tonight we are meeting on the unceded grounds of the Bidjigal people. I want to acknowledge the elders past and present who have been the custodians of the lands, the waters and the skies of this place in which we are meeting to listen and learn and to share from the experiences of our excellent panellists. Thank you so much for coming to this event to discuss disability, diversity in the workplace. My name is Dr. Leah Williams and it is my great pleasure to chair this panel tonight. We have gathered together an esteemed panel of experts to discuss the legal and social responses to diversity and disability in the workplace. And as we are sitting in the Faculty of Law and Justice, we're going to have a particular focus on legal and justice professions workplaces. We will also have some discussion of the Royal Commission into the violence, abuse, neglect and exploitation of people with disability. Though noting that the final report is due to be handed down soon, we will not press one of our esteemed panellists for any insight into what those recommendations may be before they come down. Without further ado, please do let me introduce our panel tonight. So, we first have Kate Eastman AM SC. Kate is a leading Sydney barrister with expertise in human rights, discrimination, employment and public law. Kate is also a UNSW alumna, so it's wonderful to have her back on campus with us. Since 2019, Kate has been counsel assisting the Disability Royal Commission. And in 2021, she was appointed a member of the Order of Australia for her significant service to the law, human rights and professional organisations. In August 2023, Kate was also appointed a part-time commissioner of the New South Wales Law Reform Commission. Associate Professor Dr. Scott Avery joins us. Scott is a deaf and Aboriginal educator and researcher and a Worimi man. Scott is an Associate Professor in Indigenous Disability and Inclusion at the School of Social Sciences at Western Sydney University and a research partner at the First Peoples Disability Network Australia, which is an Indigenous disabled peoples-led organisation. In 2018, he authored a book called Culture is Inclusion, based on the community-led research conducted with the Australian Indigenous disabled community. Scott is also an advisor to the Australian Government on the intersection between Indigenous, disability and social policy issues. Giancarlo De Vera is a passionate advocate for disability, multiculturalism, racial justice and LGBTIQ affairs. They currently lead policy and advocacy at People with Disabilities Australia, as well as being the inaugural secretary of the Disabled Australian Lawyers Association, the treasurer of the Australian Centre for Disability Law, and the former president of the Australian LGBTIQ Multicultural Council. Giancarlo was named as one of the 40 under 40 most influential Asian Australians in 2021, and in 2022 was named as Pro Bono Australia's Impact 25. This is a list for those who are deemed as part of the social sector to have had the most significant and positive influence in social policy. And finally, but not least, we have Connor Leslie Keefe. Connor is a penultimate year student in law and criminology and criminal justice at the Faculty of Law and Justice here, and is our student representative on the panel. Connor is a nationally and internationally celebrated public speaker and debater, and the current president of the UNSW Debating Society. Connor lives with developmental disabilities and identifies as neurodivergent. Please join me in welcoming our panel tonight. Okay, so to kick off with tonight, I'd just like to go through and ask our panellists with lived experience, if we maybe just move across the panel, what has been your experience of disability in the workplace? Can you name any particular challenges or successes that you have encountered? So perhaps starting with you, Scott.
First of all, good year, which is hello and welcome in my native language of Gatang. So I'm profoundly deaf person, so have 2 cochlear implants. And a lot of my work is actually working with Aboriginal people. Often go to remote communities, and sometimes they're often standoffish because I have cochlear implants. And I go, oh, why is that? And I kind of talk with them, and they go, oh, I said, I'm actually deaf. These are actually hearing devices. And they go, you're deaf, thank goodness for that. We thought you were a copper. And which is a bit of a dark sort of undertone here, is many of the things that we might take for granted, technologies and supports that we have in metropolitan areas are often not available to people, but this idea of surveillance is very much part of the life. And I suppose my personal experience has been, whilst I'm a deaf person, and I actually say that I'm proud times 2. I'm proud to be a deaf person. I'm also proud of my Aboriginal heritage. The ability for me to stand up and say I'm proud to be an Aboriginal person is more common, but hearing people say I'm actually proud to be a deaf person, it's just starting to come, and being the chance to be able to talk about, I'm a deaf, it's actually my natural world. I wear these for other people as much as for me. But I think what we're seeing more is greater acceptance, greater visibility of disability in workplaces. I don't know, when I started at the university, there's lots of Aboriginal people that I could go to, mentors, professors, support systems, and I'm going, where are all the deaf people? But I'm comforted because I know that they're on their way, they're coming.
Great, thank you, Scott. Moving along, who's next?
As a student, I don't have a heap of experience in the workplace as we talk about the legal workplace, but I think anybody who has studied a law degree or has tried to pursue a career in law knows that the career or profession starts when you attend law school and when you do those placements and those volunteer programs and things like that. And while I would totally concur that there is a greater awareness of many different types of disability in those workplaces and in those spaces, I think one area where it is still really severely limited in people's understanding and their ability to empathise with people is in the realm both of invisible disabilities, just in terms of even physical disabilities that people might have that are not immediately obvious or identifiable, but certainly in terms of things like learning disabilities or developmental disabilities, things like autism, ADHD, dyslexia, that are disabilities, whether you're looking at a social model of disability or of a neurological or otherwise medical model of disability, like whichever kind of way you're looking at it, but are, I think, pretty chronically misunderstood. A lot of the time, those conditions are mistaken for not having adequate work ethic, not working hard enough, not being good enough, socially speaking, in a lot of those respects. And that really does tend to harm people in workplaces that are really hell-bent on networking and it not being about what you know, but who you know, and all of those kinds of things. I think that is definitely an area that I've noticed is still kind of lacking and still needs to be worked on.
Great, thank you, Connor. And Giancarlo.
I wouldn't sell yourself short, Connor, I've got to say. Even though you don't have much workplace experience, I think what you've outlined is, I would say, the lived experience of many people in the workplace. I think it stopped and started with me with, I guess, the sense of internalised ableism. Some of my disabilities are psychosocial in nature, and so this idea of, being the problem and shifting that idea from yourself to the barriers around you was a huge shift in my own experience of unpacking and unravelling my own internalised ableism. And you do that in the workplace because and I think. And I actually started here, so it's actually quite emotional being here because I went to this law school as well, and I took double the time. I think some people here, some people know I took double the time to be here. And I remember I had the dean here talk about that, and he really supported me. The former dean, David Dixon, greatly supported me in trying to come to that realisation. He probably didn't know it at the time, so I didn't know it at the time. But that journey of trying to shift that burden from yourself away and taking ownership over the fact that you're not the problem is a huge learning that we need to take away in all workplaces. Disability isn't the problem; it's how the workplace accommodates disability.
Great, thank you, Giancarlo. what each of you has really raised there is the interrelationship between social attitudes and expectations or perceptions around disability and how they can manifest in the workplace. I want to turn to look at legal and justice profession workplaces and ask all of you to maybe reflect on what you think legal and justice professions need to offer, or the role that they play in promoting and advocating for people with disability, whether it's as employees or whether it's more broadly people with disability in the community. Maybe Kate will bring you in first on this one, as you haven't had a chance to speak yet.
Well, thank you very much for inviting me and to be part of this fantastic panel. I always defer to my colleagues with lived experience of disability on this, so I'm a bit nervous to go first. But if I get it wrong, Giancarlo will pull me up. What I will say, and I'll speak perhaps a little bit from the experience that I've had over the last 4 years working with the Royal Commission. And the Royal Commission is a legal type of body. And what I've really noticed is that as lawyers, we are very bound to words and the text. And we assume that anyone who's going to engage with us in the law will also come with us on being bound to words and to the text. And as lawyers, we're very rules-based, and we are very often certain in our positions, and our positions can be very binary. So the way we think as lawyers is not always reflective of the way in which we need to engage with our clients and with our colleagues, particularly when our clients and colleagues may have lived experience of disability, and they need us to adjust the way we engage rather than expect them to have to fit into a very text-based, structured, rules-based process. So I think as lawyers, we have to think really carefully about how we engage. So I should have introduced myself, and I was very conscious of it, saying, my name's Kate. Today, my hair's tied back. I have my old black glasses on. I've got a colourful coat, but I'm otherwise dressed like a lawyer, all in black. And so even a simple description of yourself to introduce yourself is hopefully me not making an assumption that everybody in this room can see what I'm wearing, but also understand that the wearing of all black is very much part of a lawyer's uniform. So thinking about how fast we speak and the language used are things that I really notice as lawyers that we could do a little bit better on. Giancarlo.
Thank you.
I think from the perspective of Disabled Australian Lawyers Association, one of the biggest issues that disabled lawyers experience in the workplace is the issue of disclosure. There is the stigma that still exists, especially in legal workplaces where, excellence is expected from within and around us. And so the expectation that you can't be your best because you have a disability is really rife. And we always get questions around how to safely disclose in the workplace, because the sad reality is that the DDA, so the Discrimination Act, doesn't necessarily provide sufficient protection. I'm going to get a bit nerdy here, and for those who are discrimination, nerds like me, we have provisions of around reasonable adjustments that just aren't fit for purpose at the moment, following a case known as Sklavos in the federal court. And it's concerning that we have a key piece of legislation that doesn't support our safe disclosure in the workplace. And so some of it's lived because of internal barriers, but some of it's structural, like the DDA. And so we have to really, grapple with the question that Kate's raised around what we can do in respect, what can we individually do to create a prevention culture around discrimination? The Australian Human Rights Commission has recently spoken about this idea to instill a prevention culture as we look at potentially reframing Australia's approach to human rights. And that's really at the heart of the prevention culture is what can you individually do, as well as what can be done structurally. And so hopefully just by using like what I said just then to understand that, you know, this is a dual track conversation. You've got to have a conversation around what one can do and what others can do to support that change individually, to support the systemic change that's needed.
Great, thank you, Giancarlo. And that systemic change is something that really starts in law school. So to change tack just a little bit, and we'll come back to talking about the role of legal and justice professions with you in a moment, Scott. But Connor, in terms of your experience as a law student, do you recognise some of the structural issues that Kate and Giancarlo have raised in what you've experienced or what you know of others' experiences?
I think I really identify two issues with the way that accessibility is managed at a law school level and in a kind of transitory period into the legal profession. And the first is with the kind of provisions that that Kate and Giancarlo are talking about, and whether or not people are actually accessing the help that is available to them, or whether, as Giancarlo said earlier, people have a sense of internalized ableism and don't want to identify as disabled, do not want to identify themselves, do not want to like paint a target on themselves and access that support and disclose. So that is certainly an issue that I think also starts at the law school level. The second issue that I've come to reckon with towards the end of my degree and into that transitory period is, I think, in hyper-competitive professions and environments, people really cling to just world fallacies in ways that I think really hurt people. People have a bit of an obsession with the idea that if you do things properly, if you check all of your work properly, if you network with just the right people and in just the right way, if you're charming and endearing and you go to the courtship cocktail evenings and you do all of the right things, that you will have a career and you will form the connections that you need to do so. And when you want to challenge that, when you want to say that there are people who can't socially manage those situations and that is not their fault or an indicia that they will be a bad lawyer, or that there are people who might turn in work with spelling mistakes, or there are people who might need an extension on a deadline, that does not make them any less worthy. The other side of that coin is it implies that the rest of those people who do not live with disabilities are not any more worthy for doing things that they desperately want to do to prove that they are worthy in a really hyper-competitive environment. And that is a cultural shift that I think needs to happen in the legal profession and in the way that we academically, I guess, prepare people for the legal profession, that is really entrenched and really, I think, difficult to challenge because it doesn't exist in a black letter law written down somewhere. It exists in the minds of everyone in the legal profession when they judge the people that come before them and judge them as worthy or not. So it's, I guess, a two-pronged approach. And one is reforming things like the DDA, reforming things around disclosure, which I've also identified as a problem. I was personally shocked, for instance, when I was told in my ethics class at this law school that I would have to disclose like certain disabilities that I have to the Law Society in order to even be admitted, and the kind of judgment that I might face from that process. But also, I think that informal or those social and cultural institutions that come alongside elite professions like law schools and like the legal profession really also need to be talked about.
Yeah, thank you so much for that, Connor. And it's really internalising those self-censoring behaviours or that need to, not challenge the inadequacies of some of the structures that are put in place, accepting them and forcing yourself to live through them. Scott, can I turn to you and ask what you think the role of the legal and justice professions is in promoting and advocating for people with disability? And this is something that you do really specifically with Indigenous communities, but you may have a broader view as well.
Yeah. So I've never actually been a lawyer, so I'm very much a community person, but I work with the legal profession, I work with educators, I work in... So I kind of have this cross view. I'm always fascinated about the professions and their rituals that they have. Now, the issue that I'm mainly involved with around justice is around the incarceration, particularly of Aboriginal people, but also people with disability. Again, this idea of intersecting if you're both an Aboriginal person and a person with disability. And we know from the data that if you're an Aboriginal person in New South Wales, a young Aboriginal person in New South Wales, you are 24 times more likely than someone who is not Aboriginal to be in youth detention. If you then add intellectual disability or sensory impairment, that goes up to 215 times more likely. You are 215 times more likely to be in jail. in detention compared to someone who is not an Aboriginal person and not with a disability. You kind of look at those numbers going, how's that saying? So you look at how institutions have operated. So I look at the legal profession and I kind of going, well, I go, how are you trained? How are you conditioned? Really fascinating profession to work with, because on one hand, you're trained in the values of rights and justice and really passionate about that. The other side of your training is the respect for stability of institutions. And the thing is, some of the institutions that are incarcerating Aboriginal people with disability have their origins back in the early day of the colonies, and their function was actually to remove people from society. So they were removing Aboriginal people from society. Special purpose prisons were one of the early onset institutions in the colony, and things odiously named now asylum houses and what they used to call idiot houses. They used to basically pick up people in the colony and remove them from society. So you have a look at the function now and you're going, well, how can we change that? But we fast track and it's like, well, that's what we've always done. That's the function of institutions. So we have to, this generation has to get out, move away from being prisoners to precedent and actually go, we actually need to make a change. The function of the institutions has lost its way. And I think the legal profession are the front line for that. And I think the ability to reflect on being actually change is hard work. We have to overturn, centuries of institutionalised practice and confront that. And it takes a lot of courage, I think, for this generation. That's the dare for this legal profession, I think, this generation of legal practitioners.
Great. Thank you so much for that, Scott. So thinking about maybe what the legal profession can do and how we can maybe think about those structures or navigate those structures in order to break down some of those barriers or identify some of those structures and work towards, destabilising those institutions perhaps. Let's turn to a discussion of the Disability Royal Commission and how the public hearings for the Disability Royal Commission were held. So this was a process that is an incredibly legal process, but is one that had to adapt itself because of the subject matter that it was dealing with and the nature of the witnesses who were giving evidence to the Royal Commission. So Scott and Giancarlo, I know you were both involved, both as witnesses and experts. Would you like to share some of your experience in how you navigated or found navigating those legal structures, even compared to other legal structures? And then Kate will come to you to talk a little bit more about the nuts and bolts of how those structures were adapted. So maybe Giancarlo, let's start with you.
I've got a permission to be critical, okay. It's a different power dynamic as opposed to being the witness.
Say nicely.
No, I will start nicely actually, because I think this commission, this Royal Commission, was very unique in the sense that it made a lot of changes to how to make witnesses feel more safe, more willing to be able to tell their story. But on the flip side, there were still structural barriers. I was part of a campaign to make it safe to speak, and that's because there wasn't privacy protections in place to tell your story in private sessions to this Royal Commission. And it took about, you could correct me, but I think it was maybe a year and a half. I can't remember. It took a while, right? And so obviously there was a lost opportunity when people couldn't tell their story because they felt like there would be legal repercussions by doing so. And so, but by the same token, this Royal Commission, by virtue of its letters patent, really had really key opportunities to make it easier. And my lived experience of it was exactly that. Kate and I spoke before the hearing. I spoke with a team, the accountant, the Office of Assistant Assisting. We spoke about that. In not just in the way that I gave evidence and how I was going to give evidence to the Commission, but also and the ways in which I can help bring the lived experience even more, because the early criticism of this Royal Commission was the fact that the Royal Commission wasn't focusing on people with disability enough. And so, there were times in certain hearings where there was an open door to some extent where I was able to say, here's this case, here's this case, here's this case. And it'd be obviously up to the Commission to decide whether or not they want to pursue them as a witness. But it was an open conversation that I felt that I could have with the Royal Commission, because you wanted to make sure that the right lived experience got through the door, because obviously as lawyers you make decisions based on what you hear and what you know. And so that was incredibly different compared to other Royal Commissions. And the other thing I want to just highlight is that this Royal Commission was very unique in the sense that it had explicit reference to the human rights framework, which, unlike other Royal Commissions where you might expect that to be the case, it just wasn't there. So, the Child Sexual Abuse Royal Commission, for example, didn't have reference to the Convention on the Rights of Children. And so the fact that we had that meant that I could come in as a witness and advocate with really strident conversations around human rights that the Commission will have reference, or should have reference to, and that was a really important role we had to play as witnesses, because the sad reality is the Convention on the Rights of Persons with Disabilities isn't sufficiently embedded in domestic law. And so it was kind of the role that we played, as particularly my role, and when I was given with Kate, I talked about that really high-level human rights conversation, and that's in itself another way it was very unique.
Great, thank you. And Scott?
So my engagement with the Royal Commission was not my personal story, it was the story of my community, the First Nations people with disability. And you mentioned in the introduction there was a process we called cultural inclusion, which was actually a research project that we did from the First Peoples Disability Network. And we went out and we spoke to as many Aboriginal people with disability as we could find, and we had one question: what is your story? And so we had gone through that, and this idea of truth-telling, the ability to tell your story on your terms, in a safe place, we'd kind of foreseen this, and the idea of we will believe you, and people told their story. So the Royal Commission became another platform for other people to tell their stories, so more people to tell their stories. And what we had gone through is saying, what you may have seen in the Royal Commission, there was this whole community process before, and there will be this whole community process after. Because telling the story, telling your trauma story, there's a lead up to that time when you tell the story that needs to be supported. And this is where community, the power of community in supporting individual people in telling their stories, I said that's what community done. And I think our engagement with the Royal Commission, they respected that and they understood the traumatic nature of it. But what needed to happen afterwards was actually you telling your story is part of your own personal healing and part of your own personal empowerment. And I think that's what came afterwards, the coming together. So it was like, oh, you told your story. Hang on, your story's the same. That shared experience, even though it was an unpleasant, negative shared experience, actually brought community, that group of people together stronger. And I think that's how we want to see, whilst the Royal Commission is uncovering it, the real strength is in community coming together to continue that healing process.
Great, thank you. And Kate, so Giancarlo and Scott both spoke about the fact that the Disability Royal Commission made real efforts to be inclusive with, some perhaps missteps along the way. But as someone working with the Commission, as counsel assisting, what was the difference for you in this Royal Commission compared to other legal processes that you've been involved in before? What was different about the way that witnesses were prepared and dealt with as part of the Royal Commission?
There were lots of differences. The Royal Commission is not a court, and even though there might be retired judges as part of the Royal Commission, it's not a court. The rules of evidence don't apply in a Royal Commission, and counsel assisting has a lot of power in a Royal Commission in terms of the way in which the hearings are conducted, the type of evidence that's presented and the way in which we do things. So it's very different to litigation in a court, which is very controlled by the rules of evidence. With this Royal Commission, it was very clear that the government wanted the Royal Commission to take a person-centred approach, a rights-based approach, and a trauma-informed approach to the way we did everything. So unlike normal litigation where you don't have the opportunity to practice giving your evidence, there's no counsellors around to debrief, there's no adjustments made to give your evidence in other than spoken English, we basically said we need to make adjustments to everything that we do, and we don't necessarily know what adjustments we should make. So we need, as far as possible, people with disability from our advisory groups, from the peak organisations and from our witnesses to work with us and tell us what do we need to do. So as the hearings developed, and we did 33 substantive hearings in the time that we had, I encouraged witnesses to be bolder and braver in working with me to think about the ways we could give evidence differently. And so often people came as witnesses to give evidence in the Royal Commission because they had already participated in one of our community engagement programs. So Scott was involved, I think, in some of our First Nations engagement. And Giancarlo with the community groups were involved in our community engagement. And so we would hear people's stories at community forums. People could also give their evidence and their information in private sessions, which was just a one-on-one with the Royal Commission, one Royal Commissioner, and it was super confidential. And one of the issues which I think you raised is people was a bit worried what's going to happen with the information after the Royal Commission. But the government amended the legislation to make sure that that information will always be safe. And sometimes when people are given their stories in a private session, they then said, I think I'm ready to actually speak about this in public as well. So then they would meet with me. We had counsellors who worked with us all the time. And I think initially, I think I can say this even though we're being taped, in the first sort of few months of the Royal Commission, the counsellors would come to all of the witness meetings with us. And I got this feeling that they were there thinking that we've got to wipe up the mess after these lawyers have been through. I was a bit like, okay, it's not going to be quite that bad. But as it evolved, it ended up being far from the counsellors having to clean up after the mess was involved, but more it became a way of making sure we really built in trauma-informed processes. And the other is, and a big shout out to your story, which was a specialist legal centre set up to provide support for witnesses coming to the Royal Commission, is that witnesses had the opportunity to get their own legal advice, to be supported by their own lawyers through your story and through other lawyers. And so we wrapped around our witnesses as much as we possibly could to make that process of telling their story important. The other thing I did was I was not going to shy away from having the most confronting stories of violence and abuse being heard. I was not going to sanitise what were quite disturbing and confronting stories. And I felt that we as a community needed to sit, and I said this on Friday at the closing, with the scars, the grief and the trauma of people with disability telling us what had happened to them, but to do it in a way where we were bearing witness with them and not just watching them. And so I really had to think about, as a lawyer doing cross-examination and examination, to completely change the way you would ordinarily do that. So any of you who've studied evidence, or if you're doing evidence, your trial process, you'll be told closed questions, and open questions for chief and all those sorts of rules that you learn in asking questions. I just went to my team of counsel assisting, out the door, that's over. The idea that you can't coach a witness We never coached witnesses in the Royal Commission. They told their own stories, but if they wanted to have a practice run before, I was very happy to do that. Now, that didn't change their evidence and I didn't tell them what to say, but doing a practice run of giving your evidence before you actually had to give your evidence in front of the Royal Commissioners. So you got to see how the hearing room was laid out. And that meant that my witnesses could say to me, I really don't like the chair, or I wouldn't mind a screen up so that I can see you, but I don't want to see everybody else and I don't want them to see me. It meant that we could distort people's voices. We could do all sorts of things that you wouldn't be allowed to do in a court. And sometimes people wrote their stories down. Other times they did some dot points. But I just took a lead from the witnesses. So what I try to do is sort of reverse the usual way where counsel controls the room. I wanted to basically put those witnesses at the front so that you could hear their story rather than just listen to the questions that I was answering. That's for the witnesses with lived experience. Old dogs can't change their tricks. So when it came to examining government officials or service providers, I got back into my old mode of cross-examination. But I wanted to think about into the future, how do we take different ways of giving evidence? And I was particularly conscious, and I'll stop in a minute, Leah, of some of the witnesses who are non-verbal and who can't read and write. They don't use spoken English for communication. Their communication is in sound, in touch, in gestures. And how did I ensure that they would have an opportunity to give evidence at the Royal Commission? And in that respect, we did things through video, through art, through pieces of craft. One witness had prepared like a tapestry for us, and I just had her evidence in the hearing room for the whole time. So I felt in 4 years I've still got a lot to learn about better ways of doing things, and I'd really like to sort of see the legal profession think about different ways of being able to take evidence that's still reliable, still got credibility, can be tested, but can just be done in a way where we adapt differently. So the other thing we did is everything was live broadcast. So if I made a blooper, I didn't have much opportunity to fix that. But you will sort of see from the Royal Commission's record of the hearing an opportunity to see the mix of the way we tried to engage with our witnesses. It was very important, last thing, very important for me to have counsel assisting with lived experience of disability. There are not many barristers with disability in Australia, and so I picked them as best I could with the commissioners, and so that was a very important thing. There's one of my colleagues who is the only barrister in the country who is fluent in Auslan, although you might remember her in the hearing 29. But even though she said I'm fluent, but I'm not legal fluent in Auslan, but she did part of her opening in Auslan. And so it was an opportunity, I think, for us to really sort of test and think about as lawyers, what are we doing and how can we do it better? So sorry, Leah, that's a little bit of a long-winded answer to your excellent question.
Oh no, it perfectly leads us into our final question. With all of the issues that you just identified there about how the law is often incompatible with the intersectional experiences of people with disability, these kind of notions around credibility and reliability, and that the only way for that to be achieved is through adversarial oral evidence. I want to ask each of you on the panel what you think are some current or upcoming opportunities that may be coming to build on the work of the Royal Commission, what the Royal Commission through its public hearings has shown is possible in order to either make changes in the legal realm or influence or change social attitudes towards people with disability. So Connor, we haven't heard from you in a little while. Would you like to tell us what you think?
I think as someone without direct experience of working with the Royal Commission, I think, but also as the youngest person on the panel, I think the most significant thing that I've noticed as an upcoming opportunity to reshape the way that we think about disability is a kind of growing awareness for the breadth and depth of the experiences of people with disabilities, is more people being empowered to tell their own stories about their lives and their lived experience of disability. But I'd note with the caveat that as that conversation has progressed alongside it, there have been a series of pretty harmful narratives, especially in the realm of invisible disability or of neurodivergence or of those other kinds of disabilities, that it's all young people making it up, or that people are faking it, or that people are exaggerating. So I think we're at a little bit of, in terms of the discussion around those types of disabilities and those experiences, I think we're at a little bit of a bottleneck discursively, and I think if we can make it through that bottleneck with I think empathy and compassion and believing people when they tell you their stories about their lives, which is I think very much reflects the sentiment of the panel in our previous discussion about the Royal Commission, then that is a very promising source of social change and discursive change for people with all kinds of disabilities.
Great, thank you. Scott, what do you think are some current or upcoming opportunities to build on the work of the Royal Commission or to change attitudinal views towards people with disability?
So I think for this room, I think the learning is that justice is bigger than the law. And people who experience injustice doesn't unmagically happen. I think what we saw from the Royal Commission time and time again, that people's experience of marginalisation, isolation, discrimination is actually trajectory. They're actually manoeuvred into situations where they are made vulnerable to these experiences. It is not inherent in the person, and often the injustice starts with the circumstances they're born in, carried into their early childhood, into their schooling. They may have had disrupted schooling because of ableism in the system, embedded in the systems. They may be suspended from school rather than supported, because there's an undetected disability. So I think if we care about justice, I think we need to start looking at ways we can interrupt that trajectory, both in and at different points. So some of the exciting things that are coming or promising things that we're starting to consider now is different ways. So there's a program I know of in Queensland where young people coming out of juvenile detention are coming into art groups. And they come into art groups because they tell their story through art, but they also start forming connections. They're part of a community. So this is this segue, this stepping stone where they build their self-esteem and health and well-being before they go into their economic inclusion or going into, getting a job or getting in an education. It's understanding that we need to integrate justice and the well-being. I think they're inseparable. And I think we need to find much more collaborative ways to broaden our view of addressing the broader injustice. Rather than just relying on what one profession expertise might do, we need to bring all in. And I think that's where the opportunity coming out, the healing pathway coming out of the Royal Commission, that we need to invite all into.
Great, thank you. Giancarlo, would you like to speak about maybe some upcoming legal opportunities or opportunities in the legal realm?
First, I just want to say I loved what you said, I really think you this idea of we're at this really interesting discursive point, where there's been a lot of awareness raising at the moment. But one thing that I keep thinking as a systems advocate is we need more change to happen in the formal mechanisms that can affect the change that we want to see, because at the moment, we've got there are all these push and pull factors that's got to push for these formal mechanisms to change. Like one obvious one at the moment is this renewed push for human rights acts, a human rights act at the national level, where there's a joint parliamentary inquiry into human rights next week. One of the key things I'm going to be saying to that committee is that we've got to embed our human rights. There are obviously jurisdictions in Australia where there are human rights legislation, like Victoria, Queensland, and the ACT, but they don't embed specialist treaties. And what I mean by that is like the CRPD. What I mean by that is the Convention on the Convention on CEDAW or CROC and all these other human rights instruments that Australia has signed up to. And that's because they're all focused on the ICHESCA and the ICCPR. So, and there's a real need for us to have that embedded, because I highlighted it earlier. These rights aren't embedded in our systems of law here, and one of the things I think that is going to be a huge aspect of trying to shift from this formal need to push for equality and transformative equality at that is this attitudinal change that needs to come with it. And a huge tool for that change will have to be discrimination law and the harmonisation of discrimination laws across this country. And I'm looking at Kate because she's at the Law Reform Commission, and this state's anti-discrimination laws are being reviewed currently, and so, and they're at the start of the process. And you'll probably read my submission eventually, but the first thing I'm going to say is that we've got to go from substantive equality and aim for obviously transformative equality and there has to be this positive obligation on duty holders to be able to ensure that that there is this cultural change to get to that point of prevention that I mentioned earlier.
Great, thank you so much. And Kate, final word. Obviously, we can't ask you about the Royal Commission, and we wouldn't want to put you on the spot about the work of the New South Wales Law Reform Commission at the moment. But overall, are you feeling optimistic about the law being able to take on what we've learned through the Royal Commission, what we're learning generally as the discursive point that we're at, as Connor put it? Are you feeling optimistic that change is possible, or do you think that there are barriers in place that are going to be quite difficult to shift?
I'm always optimistic, but I'm not optimistic without recognising that the barriers are there. But I'm optimistic that those who have the opportunity to address the barriers are more aware of the need to do so. I think the chair of the Royal Commission said in the closing hearing on Friday there'll be many recommendations from the Royal Commission. So I think it's likely that those recommendations are going to touch on the topics that you've heard in the hearings and issues papers and the research reports. The Disability Discrimination Act's 30 years old now, and it could do with a bit of a tidy up. The Australian Human Rights Commission certainly has, as part of its position paper on a Human Rights Act for Australia, also a position and a discussion paper in relation to discrimination law reform, and the Commission sees a Human Rights Act and discrimination reform going hand in hand. So I hope that discrimination law is a very prominent feature of the discussions about moving towards a Human Rights Act. On the New South Wales Law Reform Commission, please send in some submissions. We're very keen to hear from the community about what you would like to see as changes in New South Wales. And submissions, I'm told, don't have to be particularly long or detailed, but share your experiences and what you'd like to see happen in New South Wales, and that's a process that we're just sort of starting. But I think there's a few other things. I think the NDIS review is a very important step in rethinking about how we support people with disability in our community. The DES reforms are underway, and that's very relevant to how we started the discussion this afternoon on the question of barriers in the workplace. I do think work that the NDIS Quality and Safeguard Commission has done on its own motion reviews in looking at the experience of people who are really segregated, living in group homes, who may have no advocates or families to stand up for their rights. I think the QSC has done a very good job in starting to say it can use these powers to conduct those investigations. So the Royal Commission's coming to an end in 9 days' time when the report's delivered, and effectively the Royal Commission hands the baton over to the experts in the field, but also the peaks and to the broader community. And so my hope is that you'll receive that baton with warmth and that it provides an opportunity for further advocacy for change. I'll do my best to support you all in that exercise, but I'd like to see people with disability absolutely right at the front of leading the charge of change, and that nothing about us without us really becomes embedded into our culture.
Great. Thank you so much. Can you please thank our panel? Now, we have a little bit of time for questions from the audience. So if anyone has any questions that have been sparked by the fabulous discussion that we've had so far, please just pop your hand up and someone will appear at your side with a microphone.
Hi, first of all, I'd really like to thank the panel for their incredible insights today. As two student lawyers sitting here today, I think who are obviously looking to enter the legal profession as very junior, at a very junior level, what are some steps that we as junior lawyers and advocates can take, or some conversations that we can have with perhaps our seniors to work together with people with disabilities in the workplace?
Who would like to take that?
It's a very hard question you ask, because I'm trying to think what I would have asked. I think one thing that I have really admired about people, no, I don't want to give away my age, but one thing I really admire about people at school now has been their tenacity to ask for change, and I think and that shouldn't go away, and it's a spirit that I want to encourage, because that, you know, dovetails into the things I've already spoken about tonight around disclosure, around the systemic barriers in place. You can't affect change unless you ask the questions and imagine something different. And so I know that's really abstract and airy-fairy, but in saying that, being curious is also a huge aspect of needing to do something differently too. And so going outside of your own lived experience is probably the best advice I can give to someone starting off, because you never know where you'd end up. I didn't think I was going to end up in my role now, to be honest. I was going to go international development to the UN. And that's obviously not necessarily what's happened. But it's taken me there. Scott and I were in the UN last year, but it hasn't led to the career that I wanted. That's because you have to be curious and have an open mindset at a longer time horizon.
So my response to that is, you got to understand that social change is a process as well, and often starts with how do you start the discussion. It's really good opportunities you can look for. So in December, International Day of People with Disabilities, the 3rd of December every year, go to one of your partners and say, could I invite a speaker just around International Day of People with Disability? Plenty of people from the disability would love to that. Just to say, hey, this is the kind of issues, and it's getting them to think about things. And then you might say, you move from that, oh, that went really well. Does anyone at this event want to get a bit of a group together? We can do that. So understand about, we're not expecting you to come and, jump straight in, to the deep end. Understand what you can do to start discussions, and if you invite people with disability to tell their stories as often stories that they haven't heard before, that's what they'll do. And then, it breaks down, though. That's how you break down some of the barriers. So there's some look for chances, events, opportunities that you might start that.
Thanks to the panel for the lovely discussion. I always thought that it is your attitude to get over your disability. And that's the reason why I completed JD at the age of 76. I completed JD at the age of 76, and I was tested by the UNSW, and I had confirmed disabilities. And at that age, you can understand, I had to work 3 times harder than those who were studying with me. What motivated me was that I wanted to bring about a change in the social system, because during my work I had seen there are a lot of people who had no access to justice. Now, when I wanted to get a job in an area where I could support this sort of thing, it was only the government. And after 6 months of, how tough the tests are for a lawyer to enter, when I came ultimately through those 9 tests and at the final interview, and that at the final interview, at the final line, the person said, "Oh, would you be able to work with juniors who will be your seniors and 40 years younger? And afterwards, I never heard from them. So it is not my attitude. It is the attitude on the other side. Unless and until you change that attitude, you will only support and give a handout to the disabled. You will not give them self-esteem and self-respect.
Sir, I honour your struggle. I just want to say that to you. Be proud of your struggle. When you finish your degree, you will not only have a qualification, you will have a survival story. And with your survival story and your qualifications, your capacity to change things will be unique in this whole university. So all I can say to you is keep going.
I've completed it. I've already got GD, I've got GDLPP, I've got mediation, I've got everything required.
Others on the panel, would you like to respond to some of the themes in that question around how it is that people with disability internalise some of those structures and then what they come up against in the legal profession and how we can reconcile those two things?
The legal profession is an old conservative profession, and we've talked about this before. It's sort of stuck in its ways in many respects because it works by hierarchy and rules. The legal profession as a whole often makes assumptions about people's capacity, who's in and who's out. So every interaction that you might have on looking for legal jobs or working in the legal profession are not going to be perfect. But I think your experience is an opportunity for all of us in this room to listen and to hear about that experience. And if we're in the position of being on an interview panel, and that's one of the questions that might be asked, we say to our panellists, we don't need to ask that question. It's not relevant or necessary to the work the person's going to do. So sometimes questions are asked in interview panels because that's the questions that always have been asked. It used to be asked about women. What if you get pregnant? How are you going to be able to work full time? And those questions aren't asked anymore. They're not relevant. So sharing those experiences is really important for us to learn. But I can't tell you that the legal profession is perfect and that every opportunity that you take to get a job is going to be successful. So it's, I think learning and sharing those experiences is very helpful. However, I will say one of my other sort of hats that I wear is I chair the Law Council of Australia's Equal Opportunity Committee, and my job there is to look at the way in which diversity can better be improved in the legal profession. And so we are trying to do a number of initiatives that encourage law societies and bar associations over the country to better improve their diversity activities, from better data collection, because we don't really know how many people with disability work in the legal profession at all. We don't have that data. We don't really collect it and we don't know how to collect it. So we're looking at opportunities of making the legal profession more aware and more proactive on diversity in all of the areas, including disability. So as law students, if you've got ideas about these things, you can always contact me and I will feed this through the work that I do in the Law Council. So that is a very helpful story you've told me, and I'll bear that in mind when we do our work on interviewing in a manner that is appropriate to ask questions for people from diverse backgrounds, including an older person with disability. So I've got it, stored it, I'll use it.
If I can quickly make a quick comment and then share an anecdote with you. Your visibility is powerful, and I need you to understand that. And I think people, and the pride that comes with that is really, is got to make a huge difference. I've experienced something similar. You made me think of a story where, I talked about how it's gone out at the UN last year, and Rosemary Keys, who some of you may know, is a discrimination lecturer here at this law school. I went there. This is the first time I went to the UN for a while, and I had pink hair at the time. I decided to dye back to grey, And I was like, oh, because, the UN's going to be boring and stuff, and conservative, blah, blah, blah. Rosemary Keys I've known for a long time because she taught me discrimination law here, said, John Cully, you're a bit bland. And she's like, where's your colour? And literally the very next day I wore a dress because I identify as non-binary to the UN, and it was because she told me that. And she made me feel so empowered to be different and to be who I wanted to be and challenge who I thought I needed to be in a hallowed hole like the UN. And that's the fact that you can hold that, I guess, courage in yourself that it's the other person, not you. That's really powerful.
Yeah.
I had an experience when I was going through my PhD. So when you do a PhD, you have to submit your research proposal to an ethics committee. And I wanted to interview people in Auslan, deaf people in Auslan. And they come back from the ethics committee and they said, you need to do special procedures to determine whether deaf people have the capacity to consent to research. And everyone's laughing. I said, this is a accredited medical research body. Now, I was brought up in the Aboriginal activists, so we just kind of go, we don't mind these things, we don't mind a bit of a stoush. So we said, that's a really interesting argument. How about you bring your argument to the Disability Discrimination Commissioner and I'll take mine. And please bring your A game because we've heard it before. And I tell this story now because people go, oh my God, but I reckon there might be a few people in the ethics group who still go, oh my God, we don't have to do that. So again, it sounds bolshy now, but when we're doing it, it's really, really hard work. But standing up, you're not just standing up telling your story for yourself. You're standing up so someone 5-10 years down the track doesn't have to tell their story. And I think when you see that and take that almost for ours, it's a community obligation. We don't have a choice. But I think that's where you get, find your power is actually in being able to tell your story.
And Connor, do you want to reflect finally for us on whether you've grappled with this, going for jobs in any positions that you've been in, even at law school, this notion of, what is my responsibility and what is their responsibility, and how do I, as a person with a disability, ensure that, what I'm coming up against isn't just simple ableism?
Oh, I have a bit of a sad story on this one. I was interviewed on Tuesday today's Tuesday. I was interviewed yesterday for a position over the summer, an internship. And even though I'm here and speaking on this panel and have talked about this stuff before, and I'm generally pretty comfortable in my identity, this was an internship program for the government that had an affirmative action disability stream, and I didn't apply for it. I applied for the normal stream because I don't know. I couldn't bring myself to do it because I'm fairly used to having to reflect on the experience where lots of people don't think that things that I grapple with are disabilities. And I think many people are in the same position. I've had people who have applied for jobs who have dyslexia. I've had people who have applied for jobs who have other kinds of developmental or invisible disabilities. And they've looked at that procedure which is on the face of it really good, right? It's really good that there is an affirmative action stream for people with disabilities. There was also one for Indigenous people in the same program. That's really good. And people have looked at that and either immediately self-selected out because they don't they don't identify their experience as being as one of disability. I've had this conversation with people where I've suggested that the things that that because of the things that they have going on with them, they are potentially a disabled person, and they have gone, what? Of course I don't have a disability, or they do identify that they might experience a disability, but look at that and go, well, the person who is selecting for this job will select me out, or they will ask me what I have going on with me, and then go, no, sorry, we were looking for somebody who is vision impaired, or we were looking for somebody who has a mobility issue, or we're looking for somebody who has a hearing impairment, or is hard of hearing or deaf. So that's I'm still on a bit of a journey with that, and I hope I don't lose out on that job because I decided to apply for the. Perhaps a stream didn't choose to apply for a stream I might have been entitled to apply for, but that is very much something that people struggle with in my position.
All right, thank you. One more question. Okay.
The anthropologist Marsha Langton pointed to the inequities at a socio-legal level vis-a-vis Indigenous youth, and she felt that part of the solution was to train a cohort of Indigenous professionals, sociologists, social workers, anthropologists, and for that matter, why not lawyers, socio-legal practitioners. Maybe there is some kind of a resonance, a parallel to the inequities faced by the disability community. Maybe we need to focus more on encouraging people with disabilities to become lawyers.
Giancarlo, you might be well placed to answer.
It's a big question, I think, because I guess it's the story starts well before people get to law school. We have to take a life course approach to the fact that inclusive education is a problem from the very beginning of one's educational journey. And so I think we're starting from a place of privilege where we talk about more disabled laws. I don't disagree with it. Obviously, I think there's a more need for it, but I think we need to start the conversation with inclusive education first, and then when we get to that point, if we can get that done, then I think we probably will see more disabled lawyers.
And for the final word, Scott, would you like to reflect on that question about the comments about needing to have essentially a force of First Nations people trained into positions that essentially go into those systems? Do you see any difficulties with that?
I think Indigenous knowledges have a lot to teach an understanding of disability and inclusion. I'm going to actually go to my favourite story. So if you want to know Indigenous knowledge, you actually got to cast your mind back 25,000 years. Out at Lake Mungo in Western New South Wales, there's this archaeological site, and amongst this site, all these footprints in the clay, is this single right line of footprint, right footprint, right footprint, right footprint, no corresponding left footprint. And the Western archaeologists went and had a look at that. The anthropologist said, what's going on here? So someone had a good idea, and we'll ask our elder. And they said, this is a one-legged man on a hunt and is with community. And we tell this story to speak to an Indigenous philosophy of, it's like humankind, of well-being. And it pretty much summarises that every single person on this world has a place and purpose. Every single person on this world has a place and purpose. So we don't see disability. It's often said we don't see disability. So it's a way of knowledge, and I think it actually gives us a grounding for inclusion, and we can be optimistic. So it's not just First Nations and disability lawyers, it's First Nations, disability educators, teachers, judges, barristers, baristas, inclusion everywhere. It just makes you rethink every single person has a place and purpose on this world. And I think it's a fundamentally different philosophy, and I think if we can reclaim that, I think some of these justice-based inclusion, I think it just gives us a whole range of different ways of thinking and the answers that will come for that. So Maramboo, thank you for your question.
Now we are well and truly over time, so please join me again in thanking our panel for their generosity, for their very insightful answers tonight.
Hi everyone, my name is Associate Professor Kate Bond. I'm the Associate Dean Academic and the Chair of the Faculty of Law and Justice Equity, Diversity and Inclusion Committee. I think we can all agree that I've really picked a short straw having to speak after such a wonderfully engaging and eloquent group. And so I'm not even going to try to add much more, but just to once again extend my thanks to Kate, Giancarlo, Connor and Scott for your generosity of your time and your stories, and looking around this room while you were speaking, just the engagement, you held everybody, and we really appreciate you coming out this evening to speak with us. And special thanks as well to my colleague Leah, who just a consummate chair. We've got a few meetings lined up that we might want you to come in on. everyone, I think the next step is to figure out how we can further interrupt the trajectory. I loved that phrase, Scott. Thank you once again. It's very much appreciated. And yeah, let's go interrupt that trajectory. Thank you, everyone.